Dan did a really good video about the Prince Harry cost situation as to what might happen after he has had his partial victory in that claim against all the newspapers. So to jump on the back of that and justify using Harry in the thumbnail, I thought I'd go into a little bit more detail about the actual mechanics of this and what we actually have to do. Please stay with me on this, because partly I want to show you just how boring and tedious it all is. But I thought, you'd like to see behind the scenes. And this is something you might end up doing yourself, because I want to talk about something called costs budgets. They initially started out in the defamation realm as a way of sort of, because that's one area where it still is like, stupid money type thing. And the courts are trying to clamp down on people, getting involved in hideously expensive litigation. So they introduced this idea that at a very early stage, we have to say, right, this is what we think it's going to cost. That's been expanded now, so that covers all, quotes, high-value litigation. And high value could be anything like £100,000 or more. So it could be something, if you're even just in a property dispute or, something like that, it could crop up. So where to start? Well, in the words of Julie Andrews in The Sound of Music, why are we escaping to Switzerland when we clearly already are in Switzerland? But also, let's start at the very beginning, because it is a good place to start. So, somebody issues a claim, and the other side bang in their defence. At a very early stage in proceedings, something called a CCMC or a CCMH will be listed. That's a Costs and Case Management Conference or hearing. And in the High Court, you go before what we call a master. Masters are a special type of judge who deal with all the procedural issues of High Court litigation. And they actually fulfill a very useful and important role. So we'll actually do another video specifically about those. And in the, if you're in the county court or the sort of registry of one, what are called the High Court registries, that's where the High Court, because technically there's only one High Court, in the same way there's only one Crown Court, it just sits in lots of different areas. And a lot of county courts are what we call registries, district registries of the High Court. So then you just do it in front of the judge. But what you do is you file what we call costs budgets. Now, they're on a form. I say form, it's actually a spreadsheet called Precedent H, and judges have heard all the Preparation H jokes, I can tell you. And what I'll try to do is I will put up somewhere either that side or that side. I'll show you one. But in essence, it's a spreadsheet. There's a summary page that breaks everything down into sort of pre-trial things, drafting pleadings, collecting witness statements, instructing experts, the trial itself. It's also got two areas for contingency, which is, things that might arise. So you have to predict exactly what might actually happen in the course of the litigation. What if we need to do this? What if we need to do that? So there is space for that. But also within that, each of those separate areas has its own spreadsheet. And you fill in all the time you would spend on everything, how many hours you're working on things, what people are charging per hour, because different work's done by different people, what disbursements you might have. A disbursement is where you have to pay like cash to something. So a disbursement might be a court fee, it might be an expert witness fee, it could be paying witness expenses to get them to court, something like that. So each side prepares one of these spreadsheets, and you send them to each other. Then, upon receipt of each side's cost schedules, the other side does a form called Precedent R. And that looks at what people have spent. So, you fill in all the sort of claimed expenses or predicted expenses. And then you have a little column at the side where you can comment on it. To be honest, most of the time we just put agreed, because you don't want people challenging your own costs either. So there's almost like a tacit agreement not to challenge each other's costs. But you can say things like you don't need to spend that much, or sometimes you'll say, well, actually, you've already spent that, so stop putting it on the spreadsheet. That should go in a different spot. Like technical issues and things like that. But effectively, it's your challenge to the the other side's predicted costs. This is actually quite a common thing in litigation. It's what we call Scott schedules. You get this a lot in sort of building disputes, where you'll be claiming for like remedial works or something. So you'll list every single item and what you actually spent, and then the other side, you leave a column for the other side. It's really easy now. We can do it all on spreadsheets. In the old days, you have to type it all out. And the other side might say something like, we don't agree that work was necessary at all, so 0. They might say, yes, we agree that work was necessary, but it shouldn't have taken that long, so we're knocking you back on the labour. Or we agree that work was necessary, but you could have got the parts a lot cheaper at a different building merchant. Here's some receipts, so we knock that back. And then there's another column where the judge says, I don't care what you two say, this is what I say you're getting. And it's a very similar thing with the costs budget. So you go in, you sit in front of the master or the judge, and you say, here are our respective cost budgets. The judge will say, I've seen your Precedent R's, I see you're either accepting it. I mean, sometimes they can step in and say, I personally think this is a bit silly. But they never do, actually, if you sort of agree them. And that is your costs budget. Now, if during the conduct of the litigation things change, then ideally what you should do is submit a revised cost budget and flag that up early. Because if you don't, there is always a danger that at the end of proceedings, when costs are being assessed, a judge may well say, well, hang on, you did not actually mention this, so I'm just going to stick you to your original cost budget. I mean, sometimes they don't. There is some degree of flexibility there. But at the end of the hearing, you put in a cost schedule, and I'll load up one of those. A cost schedule, like I've said before, it's just a summary of what you spent. It's a very rough breakdown. They're more commonly used when you do what we call summary assessment. So if a hearing has lasted less than a day, then a judge will just assess it at the end of the hearing and go, okay, what do you say about the other side's costs? Oh, they're a bit high, they didn't need to spend that much work, that fee earner's not right. And there are also limits on how much you can claim per hour for different levels of qualified people. It goes A, B, C, and D. I'm A. That's only because I've been doing it a long time. It doesn't reflect my skill level or anything. But you can charge different rates. You can justify different rates for different levels of fee earner. And also it's regional. So, you get higher rates in London than you do in Cornwall, where it's actually the lowest rates. If, however, in big time litigation, where the costs are running at hundreds of thousands or millions of pounds, a judge will not usually summarily assess. They will make an order saying costs to be assessed if not agreed. And they go off for what we call detailed assessment. A detailed assessment, as I've mentioned before, that is where you go line by line through every expense claimed. You instruct somebody called a cost draftsman, even though, like I say, quite a lot of them are women, and they will take the case file from the solicitors and they will go through and they will itemise every single thing there and explain why it was, justified. Because the test for recovering costs are that every single expense you claim must be reasonably and necessarily incurred. And also, if it's on what we call a standard basis, must be proportionate to the litigation as a whole. So reasonable means, it's reasonable. Necessary catches a lot of people out. Because there have been cases I think are a bit unfair where people have legitimately instructed experts, but then during the conduct of the litigation, the parties have said, well, actually, we now agree what your expert's saying, so you don't need to bring them, we don't need to cross-examine them. And courts have said, well, actually, because you now agreed that, the expert wasn't necessary. And it's like, well, hang on, it was necessary because they wouldn't have agreed it if we hadn't served the expert's report. But these are things you've got to be very careful of. But normally, like I said, costs are awarded on what we call a standard basis. However, as a way of punishing bad behaviour in the conduct of the litigation, courts can say, we're going to order costs on an indemnity basis. So what's the difference? Well, on an indemnity basis, the costs must be still reasonably and necessarily incurred, but the proportionality rule disappears, so they don't have to be proportionate anymore. Also, on a standard basis, it's for what we call the receiving party. In other words, the winner who is receiving their costs from the loser, they have to justify all their costs. But on an indemnity basis, the starting position is those costs are payable unless the paying party can argue why they're not to be. So it actually shifts the burden of proof. But how else might you be ordered to pay costs on an indemnity basis? Well, it's as a result of not beating a Part 36 offer. And again, Dan mentioned those, but I thought I'll just go into actual details. And again, I'll put up, there is a standard Part 36 form you can use. And I always advise people to do that. Theoretically, you can just make a Part 36 offer in correspondence. But the rules are so technical in terms of what you say. If you get even the slightest thing wrong, I mean, normally courts are sort of fairly flexible, and it's all about the substance, not the form. But this is one area, Part 36, where they go, no, it's all about the form. It's about actually getting it right. And if you don't, then the Part 36 offer is invalid, and that can have quite dire consequences. But you do the form, either a claimant or a defendant can make a Part 36 offer, and you can make them even before litigation, which is quite common. So a claimant can say, we are claiming £100,000, but we'd accept £70,000. Or a defendant can say, you're asking for £100,000, but we offer you £70,000. Now, if the offer is accepted, in other words, the defendant says, okay, I will pay that, or the claimant says, okay, I will accept that, the rule is that you are also agreeing as defendant to pay the claimant's costs, subject to assessment. And you've got to be very careful, actually, because if you actually say, oh, and we agree that we'll pay this amount of costs, that stops it being a Part 36 offer, and it turns into what we call a Calderbank offer. A Calderbank offer is just where you make any sort of without prejudice offer, and it's not within the very strict terms of the Part 36 procedure. The good thing about Calderbank offers is you can offer other things as well. I'll give you some money, but also I'll sort out this other problem that you've been on about. Or, you can do deals beyond just the actual litigation. And where Part 36 offers can get complicated is where it's not just monetary relief. So you do them in a defamation case, and it's like, we want the statement in open court, or we want the apology, or we want the injunction. I mean, it can be done, but it's such a technical area that you have to be very, very, very careful. And the law reports are just full of examples of even like the most highest profile expert firms getting it wrong and losing out, hundreds of thousands and sometimes millions of pounds. But what happens if you don't accept the Part 36 offer? Either the defendant says, nope, we're not agreeing to pay you that, let's go to trial, or the claimant says, I'm not willing to accept that, let's go to trial. Well, it all depends on whether you beat the Part 36 offer. So if you say, we would be willing to accept £70,000, and at trial, the judge, you don't get your full £100,000, but the judge says, I think you get £75,000, you have beaten the Part 36 offer. However, what if it's been refused and you get £65,000 and the defendant had offered you £70,000? Then you have failed to beat a Part 36 offer. And the rule there is, whoever fails to beat the offer, not only do they pay the other side's costs, because the argument is, if you're a claimant and you didn't accept this offer and we went to trial, well, even though you've won, you were offered more than this at the beginning. So all these expenses are on you, so you should pay them. And similarly with the defendant, it's like, well, they offered to accept this amount of money, you've now been ordered to pay even more money. So, again, it's all on you. But the costs are awarded on an indemnity basis. And the main difference there is that, obviously you can end up paying a lot more on an indemnity basis. And it is explicitly referred to as a punishment for, not settling the case. So it gives you an idea of the sorts of pressures that courts put onto people. You also get into issues as to who actually won, because sometimes you have claims and counterclaims, but even within just a single claim, there might be lots of separate heads of damage. And what if, as Harry has done, he's only succeeded on half of them? Well, the argument, and certainly this is the argument the newspapers will run, is, well, effectively, yes, he's won on half, but we've won on half, therefore it's a score draw, and the order should be no order as to costs, because, effectively we've both won a bit and we've both lost a bit. And courts will actually, this is where you get into all the maths about it and trying to break things down and saying, how much time did we spend on this bit of the case? How much time did we spend on the other bit of the case? The one thing courts don't like doing is making cross orders. So they won't usually say the claimant owes the defendant this amount of costs and the defendant owes the claimant this amount of costs. They will actually tally it up. If it cancels out, they'll say no orders to costs. If, however, for instance, it was, well, one side owes, you owe the defendant £200,000 in costs, and they owe you £150,000 in costs. They'll just make an order saying you owe £50,000 in costs. It just keeps things, quotes, simple. I'm not aware of what order has been made yet in that case. Possibly there is no order yet, because what usually happens is the actual judgment is sent out in advance to the respective parties. Now, the idea for that is that you can just comment and say things like, there's a typo there, or you got that person's name wrong. It's definitely not an opportunity to argue and try and re-argue the case and say, well, you just substantially got that wrong, please change your mind. I mean, sometimes you can say, oh, could you just write something about this, or could you just clarify that point? But the idea is it's just to make sure that the version that goes out people are happy with, not in terms of the result, but just in terms of what it says. But what they will have said there is probably something like, could the parties address us on costs as a result of this? Here's our decision. If you have any consequential inquiries or anything that you need me to deal with, please put it in writing. So they may have invited submissions on costs. I mean, sometimes, because quite often with judgments, the judges will give their judgment, but then they'll get counsel to actually draft the order. So you'll go, say, here's my judgment, especially if they just do it, verbally, extemporare, as they say. And you go, oh, actually I had this once with somebody who said, so the judge gives a big, long judgment, and then my lovely opponent says, would you like counsel to have conduct of the order? And the judge went, oh, that's very, very helpful. Yes, thank you, I'd appreciate that. And then he just said, actually, as Mr. Robertshaw was the claimant, I think it falls on him to draft it. Like, oh, cheers, mate. But, so, you go out then and you write an order that you think reflects what the judge has decided. I mean, sometimes we've just looked and gone blankly and gone, judge has said, can you write the order? And it's like, yes. And we go outside and go, what just happened? Who won? Were you making a note? Did you follow any of that? So yeah, we'll draft up the order, but within that, we may suggest, say, like, cost to be assessed if not agreed. But sometimes you'll have an argument and say, well, and I suspect this will happen in this one, people will be arguing about exactly what the costs order should be, and it may be there's an oral hearing about that, although usually judges prefer sort of, stick it in written submissions. You spent enough time in my courtroom. Well, I hope that has shown you just some of the complexities and sort of tediousness of what is involved in costs. And to give you an idea, because costs is a notorious area, I'm going to give you a quote. The quote is, let's face it, most costs applications are two people who know nothing about costs arguing in front of somebody who knows even less. And that was a quote from a guy called Judge Cook, who was a judge. And he got so frustrated with the fact that nobody understands costs, he actually wrote a book called Cook on Costs that's really good and breaks down, it's almost like a sort of step-to-step, how to do things. You don't even have to understand what you're doing. It just makes it really easy. If you are VAT registered and the other side isn't, and you have done this, then this is what you argue, and this is what you say, and this is what the order should be. It's a fantastic book. Judge Cook has unfortunately passed away now, but the new editor of the book actually is a judge called Simon Middleton, who's our local cost judge who I've had many a happy time in front of. He's a really, really, really nice guy, and he does know a lot about costs, so he's the perfect person to be editing this book. And like I say, if you actually are embroiled in litigation, you're getting to rouse about costs, it is worth checking out, your local library or law library. And actually looking at a copy of Cook, because it is, all the lawyers use it, even all the people who pretend to be experts, they all have it stuffed away in their back pocket. Don't fall for, it looking like they pretending to be clever. None of us actually know what's going on. But anyway, as always, hope you found that vaguely useful, vaguely interesting. If you did, please consider liking, sharing, and subscribing. Like I say, I'm just really leaning into this YouTube grifting thing now, because I quite enjoy it. Yeah, I'll see you next time when I can find another sort of a trending thumbnail or celebrity to actually just to a really boring chat about the intricacies of the CPR on the back of.